Okay, so good day, good evening, and good afternoon, everyone. We are back again on the law of delict, and we're going to be talking about specific forms of delict. Now, the different types of claims that are claimable under the law of delict. We're going to be dealing with those claims and the specific elements that should be met. This is a marriage. So, firstly, seduction, where a man induces a woman who is a virgin and who is not his wife to have sexual intercourse with him. You can recover in terms of the claim of seduction. This claim is based on the laws of virginity. We talked about this in class, and I gave example. We're dealing with dealing at the customary law, the basis for the claim for seduction. Now, under general law, the claim for seduction is based on the loss of virginity and impairment of marriage prospect. Now, if a child is born, lying in expenses, maintenance for the person, and any other consequential expenses incurred. So these are the factors that they look at when a person is making such a claim for seduction. They look at whether the person is now pregnant as a result of their seduction. They look at the lying-in expenses, the maintenance, etc. Now, as customary law, seduction is committed when a man induces a woman, whether or not she is a virgin, who is not his wife, to have sex with him. Read in category. Customary law and the action itself is now adultery as a claim. I think you now know this one inside and out. I don't have to repeat most of the stuff. We dealt with this when we're dealing with customary law, but the basis of the claim is that a victim can claim from a third party who knowingly has sex with his or her spouse. And the factors to be considered when assessing damages for adultery is the decreased value of money, the show of contention, whether the person apologized or not, whether they use protection, and all that jazz, right? Now, the preferences for a claim of adultery: the wrongdoer must not have been aware that the person was married. So, to avoid popping out money for claims of delict, the wrongdoer can raise defenses to remove liability. One of those defenses is that they were not aware that the person was married. And secondly, the wrongdoer may allege that the two spouses connived for the adultery. Maybe they had an open marriage. Yeah, all those kind of things. And then the wrongdoer can claim that he or she was raped. Now, abduction, enticement, harboring of another spouse, right? Those are also the types of claims that are claimable for persons or sexual related offenses, right? You claim abduction, enticement. Oh, someone enticed my wife and I no longer I'm with that person because someone else enticed it, right? Harboring of another spouse. You go for a weekend with another person's spouse. The person can claim that you have harbored their spouse and can claim delict for that. The delict is committed by a wrongdoer if, knowing a person is married, detains that married person against his will or entitles that person to leave his or her spouse, right? In the possible defenses, the spouse is justified in leaving, and the wrongdoer did not coax or persuade the spouse. Right? These are the claims available in sexual related matters. Now, there's also bigamy, right? When a person, knowing that they are already married, tries to marry another person, right? They are committing the offense of bigamy, right? And in Svanda vs. Svanda, the court held that damages lie under actio injuriarum against the wrongdoer in terms of a claim of bigamy, because you are somewhat disturbing the person's feelings, especially when the person did not even know that you were married, right? You are disturbing a person's personality, right? And then we have the claim for assault. This one, I'm sure you're familiar with it in terms of criminal law. The elements of assault also applies here. These delicts are available when a person unlawfully and intentionally applies force to the person of another or threatens to do so in a manner that inspires a reasonable fear of immediate danger in the mind of the person threatened, right? And then we have the damages that are recoverable, patrimonial and non-patrimonial loss, if there is bodily harm, and if you have been injured in terms of feelings, you can claim. Now, defense is raised, acting under lawful authority, defense of another person or property, the person consented, provocation. Those are all possible defenses under the claim for assault. Okay, so for unlawful trading practice, the law makes a statement to death of a right. So, for example, X makes a statement to P, and P as a result X to the detriment of Y. I think I once get this example in class saying that when someone goes, I think I was talking about it under customary law. Now, this is a claimable action under general law, wherein, let's say, for example, there's a person selling something in class, right? And then I go to another person and says, the things that Tasha or something is selling, maybe it's poisoned or something like that. And as a result of my statement, the third person does not hear from Tasha, and as a result, that is at Tasha's detriment. Tasha does not gain another customer, right? So one person says something to third parties and it is to the detriment of the victim, then that person is in the wrong, and delictual claims can be claimed from that. It is committed in the wrong can fraud makes a statement to the victim, knowing or suspecting that the statement is false, and intend that the victim will be prejudiced. So, unlike the previous statement, wherein the wrongdoer makes a statement to a third party, in this case, fraud, the wrongdoer is making the statement to the victim that is to the victim's detriment, and as a result, the victim suffered some financial loss. So the victim is then entitled to claim for financial loss when those statements are made to him or her. And then we have passing off. That is another claim. The delict is committed when D misleads a name or mark of another so that the customer are misled. the victim can obtain an interdict to prevent the continued practice. Right? We see this every day on our streets with persons was it marking certain products with certain names, knowing that people are buying the name or the brand as opposed to the item itself. This item is from was it is from Coco Chanel. I'm buying this. Well, when we all know you can't find a Coco Chanel bag being sold under a tree, right? So a person who sells something or misleads someone into buying something while they are passing it off as something else, well, that person is in the wrong and you can sue that person, right? For a claim of delict for passing off. Now, in terms of false imprisonment, this is wherein if a person is unjustifiably restrained by another person, or another person is unjustifiably imprisoned, then the victim can claim for the humiliation and indignity, right? So the claim for false imprisonment is based on the humiliation and indignity of that false imprisonment. This is based on strict liability system. Intention is not required and no financial loss is required as well, right? And then there's also another thing to note, which is that it is not always police enforcement that can, against which you can claim false imprisonment. Even just private persons, from private person you can claim for false imprisonment. This is reflected in Mapuranga versus Mungate case. Please read this case. It is quite interesting. Please read it. And then we have another claim, which is the abuse of legal proceedings or malicious prosecution of own. Please read also this claim in Delict. Abuse of legal proceedings, right? Or malicious prosecution of your own. Let's say, for example, a police officer who is the ex-boyfriend of your current girlfriend decides that no, I no longer want you in my ex-girlfriend's life, and gets jealous and then goes to your workplace and decides to arrest you on charges of, was it fraud or even theft. But you know yourself that you were not, you did not steal anything or you did not commit fraud, but you nonetheless get arrested and you even go to court. When those court proceedings are dismissed, right, when the charges are dropped, you can claim for abuse of legal proceedings or malicious prosecution and say that no, this person did it with malice or with malicious intent, and support your argument with obviously proof thereof, right? However, it is quite interesting. Let's say, for example, you know the ex-boyfriend really did do all these things with malicious intent, but when you get to court, you really are charged and convicted of the crime. Then you cannot sue for abuse of legal proceedings. You cannot. You can only sue when the charges are dropped or when those proceedings, was it the the matter is dismissed, then you can then claim for abuse of legal proceedings. Now let's continue. So we talked about this. These are the requirements for abuse of legal proceedings, malicious arrest. So these are the examples and supporting case law of such. Please read this. It is really quite an interesting read and knowledge really. And then we have delicts relating to things or buildings. So you can claim from an occupier of a premise if something falls or is thrown from that premise and causes harm on to the victim, then the victim can claim from the occupier of the premise, right? And then it is quite interesting to note that this is based on the strict liability system. So fault has nothing to do with this claim, right? You can only claim when against the occupier of the building and if this has caused harm. Now, another claim is where a thing has been dangerously placed or suspended on a building or over a public way, creating the risk of injury, right? So when there's something that you can see would has potentially dangerous consequences, then you can bring this second action, for which the Latin words I will not dare pronounce, because one, pronunciation is different, and these are Latin terms, and I am not Latin. I am Shangani who knows English. So you can pronounce it however way you want, but just know that the claim is there. An action is available to interdict or stop the continuation of the hazard. So let's say, for example, you see that there is a sign hanging over a tall building, and that sign is crookedy in a way and could potentially fall to the ground. You can use this claim to remove the hazard or stop the continuation of the hazard, right, for your own benefit. Let's say, for example, you walk under that walkway every day or under that building every day. Now, delicts for interference with contractual relationships and business relationships or trading practices. So these are types of delicts that relate to contractual relationships and practices, right? Inducement to breach of contract. This delict is committed where one, knowing or suspecting another has a contract with the victim, intentionally induces the other party to break the contract with the victim. So what is happening under this claim is that I know that X and Y are in a contractual relationship. They are providing each other services and the other is paying money for those services. But then I was it then I go myself, right? And then I tell Y that this contractual relationship is not to your benefit and I start saying stuff that makes Y remove himself from that relationship and is no longer in contract with it. Then X is the one who can sue me, the third party, right, for saying such things, right? So if this one vexes you, please, you can ask questions on it. A lot of people do get confused a bit, but it's really not all that confusing. Your X is in a contractual relationship with Y, and then P, myself, goes and tells Y things that makes Y remove himself from that contractual relationship. Then X can sue P, myself, for damages, right? On the basis of this delictual claim. Now, intimidation, unlawful action directed at third parties to induce them to cancel relations with the victim. So if I intimidate someone into removing themselves from a contract, then I can be sued, right? I can be sued by the victim himself. So in that case, we have Y who sues P for saying something that intimidates him and makes him cancel the contract. And then we have conspiracy, where a number of wrongdoers working together to deliberately take action not intended to further their own interests, but only to. In terms of conspiracies, we're just saying that a number of people conspire to cause negative loss to X, who is the victim. Then X can sue those number of persons for conspiracy, because those conspiracy theories or whatever that those multiple people would have done would have caused financial loss to X. Now we are dealing with delicts from harm caused by animals. There are different types of delicts there. Some of those we talked about them when we're dealing with customary law. We'll go into detail now. What should book? I would you the photo delictual notes that I gave you on the group. He almost perfectly knows how to explain these types of delictual actions, especially to compare the types of actions that are there, right? So at Aquilian action, you can use Aquilian action to make delictual claims for harm caused by animals. If the owner or the controller of an animal has intentionally used his animal to cause harm or has negligently allowed his animal to cause harm, the wrongdoer will be held liable for patrimonial loss. So you can use Aquilian action to make a claim under the law of delict for harm caused by animals, right? Then we have an example of a case law there. Read that. Next, we have pauperine action. So this is another type of action that is claimable if animal, but in this case, under the pauperine action, we're looking at domestic animals, right? The action can be claimed against a person who was the owner of the animal at the time of the injury was afflicted, and in this case, it is strict liability since intention on the part of the owner is irrelevant, right? So it's up to you as a intellectual, as a lawyer who is learned in intellect. You look at the facts of the case and see that, okay, you you won't be able to prove intention in terms of Aquilian action, then you can try to sue for pauperine action, right? But for you to sue pauperine action, you have to know the requirements of the pauperine action. These are the listed requirements. The wrongdoer was the owner of the animal when the animal was inflicted. The animal that inflicted the harm was a domestic animal. The animal was lawfully present at the location where the harm was inflicted. The harm was contrary to the nature of its species, contra naturam sui generis, and the animal acted out of inward excitement or vice, right? So I think the others are straightforward stuff, but I can explain the whole aspect about nature of its species, right? The animal acted contrary to the nature of its species. We know as a general rule that dogs are loyal, dogs are sweet, dogs are cute AF. And if you see a dog being all harsh and brutal and, wanting to bark you, it is acting contrary to its nature, right? So when you, as the victim of a dog, sees that is harmed by that dog, when you get into court, you have to say that at the time of the delictual action, right, The dog acted outside of its normal nature. It was vicious, it just came at me, it bit me, all that jazz. You have to prove that the dog acted contrary to its species. Okay, so as a assignment for your own self, please look in available defenses. They're there in your textbooks, they're there in the photo notes, they're there in my notes. Know the available defenses under the claim of preparing action. Know them, please. Actions different is that the action can be brought about when a wild animal which is kept in captivity causes harm, right? The same requirements apply, but in this case, quasi-parent action, it is now a wild animal, right, that causes the harm, as opposed to a domestic animal under parent action. In quasi-parent action, it is a wild animal, right? And the available defenses are written down there, right? This major, that a third party was to blame, that the victim was unlawfully at a place, right? So those are the defenses. And then we have harm caused by grazing animals. Action D plus 2. I cannot repeat this one. We learned about it in class. We are looking at was it a strict liability system wherein an animal is causes damage to a wrongdoer's was it to a wrongdoer because they have went in and started grazing in their field or in their place, right? So those are the actions that is there. X and D plus 2, we talked about this in detail. Please be familiar, right? But the process is different under customary law than under civil law. The requirements are laid out in your notes, they're laid out in photo. Be familiar with them, right? And then we have edict concerning wild animals, a dictum de feris, right? Any person who keeps a wild animal in the vicinity of a public space strictly liable if the wild animal is in the vicinity of a public place, right? Strict liability system. Let's say, for example, if you are keeping an animal at a zoo, which is in near town, right? And you know a lot of people coming to a zoo and whatnot. If that wild animal causes harm to another person, then you are liable under the strict liability system. Your intention or your negligence really is not in question, but did the animal cause harm? Then you'll be held liable.